Hello, all borrowers are customers for a bank, but whether borrowers can be considered as consumers under the Consumer Protection Act and can they file case against the bank in a consumer court when the bank is initiating legal action against them for recovery of loan dues? Let's find the answer to these questions in the light of a recent Supreme Court judgment. So friends, welcome back to Bankers Plus Academy. And today we are discussing a landmark ruling by the Supreme Court of India that clarifies who qualifies as a consumer under the Consumer Protection Act, especially when it comes to project loans for profit generating activities. Let's go into the details of the case. In a recent judgment, the Supreme Court held that a borrower of a project loan for a profit generating activity does not qualify as a consumer under the Consumer Protection Act 1986. This decision came in the case of the Chief Manager Central Bank of India versus Messrs. Adbureau Advertising Private Limited, and it has significant implications for businesses and banks alike. Here is the background. Messrs. Adbureau Advertising Private Limited, a company involved in the post-production work of the Tamil movie Kochadiyan, starring Rajinikanth, had taken a project loan for rupees 10 crore from the Central Bank of India. The loan became NPA, leading to legal disputes, but was later settled for rupees 3.56 crore through a one-time settlement or OTS. The borrower paid the full amount as per the settlement, and the bank also issued no dues certificates. However, despite the settlement, the Central Bank of India allegedly reported the company as a defaulter to CIBIL and the Reserve Bank of India, citing an outstanding amount of rupees 4.17 crores. The borrower claimed that this erroneous reporting caused severe financial and reputational damage to them, including the loss of an exclusive advertising contract from the Airports Authority of India. The tender was initially awarded to the borrower but was later revoked. The reason was that it could not secure a bank guarantee from HDFC Bank, which refused due to the respondent's name being listed as a defaulter in CIBIL records. Aggrieved by the wrongful reporting, the company filed a consumer complaint before the NCDRC, that is, National Consumer Disputes Redressal Commission, alleging deficiency in service and unfair trade practices by the bank. The NCDRC ruled in favor of the company, holding that the bank was liable for deficiency in service and unfair trade practice. Wrongful reporting of the company as a defaulter, despite the loan account being settled, and causing financial and reputational loss to the company. So the NCDRC awarded compensation of rupees 75 lakhs and litigation costs of rupees 20,000 to the company. Additionally, the bank was directed to issue a certificate confirming that the borrower's loan account was settled and that the wrongful default reporting was incorrect. However, the Central Bank of India challenged this decision in the Supreme Court. The bank argued that the loan was taken for a commercial purpose, that is, the post-production work of a movie, and therefore the company could not be considered a consumer under the Consumer Protection Act. Here, please remember that under the Consumer Protection Act, a person who obtains goods or avails services for resale or for commercial purposes or without any consideration, that is free of charge, is not considered a consumer. On the other hand, the company claimed that the loan was a self-branding exercise to build its reputation and earn a livelihood and not to generate profit. So, this was the argument of the company. Finally, what happened? The Supreme Court, upon examining the case, held that the company was not a consumer under the Consumer Protection Act 1986. The court further explained that post-production of a film is inherently a commercial venture and the loan taken for such activities has a close nexus with profit generation. The court concluded that 1. The project loan was availed for a commercial purpose with the dominant intention of profit generation. 2. Business-to-business transactions such as project loans are excluded from the purview of the Consumer Protection Act. 3. Even if the loan was partly used for brand building, Its dominant purpose remained commercial in nature, and so the NCDRC lacked jurisdiction to entertain such a complaint. Accordingly, the Supreme Court set aside the NCDRC's order, allowing the appeal filed by the Central Bank of India. So, what does this mean for businesses and borrowers? Simply put, if you take a loan for a commercial purpose like funding a movie or any other profit generating activity, you cannot claim protection under the Consumer Protection Act if disputes arise with the bank. This ruling reinforces the distinction between consumer transactions and commercial transactions, ensuring that the Consumer Protection Act is not misused in business to business dealings. Also, this ruling provides clarity on the jurisdictional limits of consumer forums in matters involving business to business financial transactions. Thank you.